Hello, students. Welcome to AKS IAS. As part of our discussion on essay series and the perspectives for the mains related topics, today we'll discuss about the issue of contempt of court. So, we will be discussing about the arguments in favor of retaining the contempt of court law and the arguments against the contempt of court law. So, why are we discussing this issue in the first place? Recently, the Supreme Court of India initiated the proceedings for contempt of court against lawyer activist Mr. Prashant Bhushan. The contempt charges were lodged in the context of the comment made by him on social media targeting the current Chief Justice of India. So, the contempt power is needed to punish the willful disobedience to the court's orders. So, why is this contempt of court law existent in the very first place? Because this will prohibit or punish willful disobedience to court laws. That is the civil contempt. Also, we have criminal contempt. So, this power of contempt will also prevent the interference in the administration of justice and overt threats to judges so as to ensure independent functioning of the judiciary. The reason why the concept of contempt exists is to insulate the institution from unfair criticism and prevent a fall in the judiciary's reputation in the public eye. However, this raises the dilemma between the part of the contempt law that criminalizes anything that scandalizes or tends to scandalize the judiciary and the freedom of speech and expression. So, this is a conflict between the freedom of speech and expression, which is guaranteed under Article 19. Especially, this conflict holds more relevance in the era of social media, where the freedom of speech and expression of citizens should be guaranteed, as well as the sanctity of judiciary should be protected. Thus, the current issue has once again brought the focus on the need for reviewing the law on contempt of court. Please note that the contempt of court refers to the offense of showing disrespect to the dignity or authority of a court. So it is nothing but showing disrespect towards the sanctity or authority of the court. The objective for contempt is stated to be so as to safeguard the interests of the public if the authority of the court is denigrated and public confidence in the administration of justice is weakened or eroded. The Supreme Court and the High Courts derive their contempt powers from the Constitution of India itself. So, both the High Courts and the Supreme Court have this power of contempt of court, which is guaranteed by the Constitution. Also, the Contempt of Court Act of 1971, that is, it has been provided a legal sanctity, outlines the procedure in relation to the investigation and the consequent punishment for the contempt. The Act divides contempt into civil contempt and criminal contempt. Civil contempt refers to the willful disobedience of any order of the court, which we have already discussed. However, criminal contempt includes any act or publication which scandalizes the court, which prejudices any judicial proceeding, and it interferes with the administration of justice in any other manner. So, whenever these activities are indulged in by a person, it amounts to criminal contempt. Scandalizing the court broadly refers to the statements or publications which have the effect of undermining the public confidence in the judiciary. Okay, that is what scandalizing the court means. So, what are the arguments against this law? Arguments against this contempt law? Most of the critics say that it is against civil liberties. A law for criminal contempt gets in conflict with India's democratic system, which recognizes freedom of speech and expression as a fundamental right. Also, in this manner, the judiciary draws resemblance with the executive in using laws for a chilling effect on the freedom of speech and expression. So, critics argue that it will impinge on the freedom of speech and expression of the citizens. Also note that the former Justice of the Supreme Court, Mr. V.R. Krishna Iyer, famously termed the law of contempt as having a vague and wandering jurisdiction with uncertain boundaries. The contempt law, regardless of the public good, may unwittingly trample upon civil liberties. Number two, the wide scope of contempt. This is also one of the chief arguments or critiques. The definition of criminal contempt in India is extremely wide and can be easily invoked. Also, suo motu powers of the court to initiate such proceedings only serve to compliance matters. Further, the Contempt of Courts Act was amended in the year 2006 to add truth and good faith as valid defenses for contempt, but they are seldom entertained by the judiciary. Next is international disuse of contempt doctrine. Already, contempt has practically become obsolete in foreign democracies, with jurisdictions recognizing that it is an archaic law. For example, England abolished the offense of scandalizing the court in the year 2013. Canada ties its test for the contempt to real, substantial, and immediate dangers to the administration. American courts also no longer use the law of contempt in response to the comments on judges or legal matters. So that was about the various critiques of the contempt of court law. Now let us look at the arguments in favor of retaining the contempt of court law. Number one, high number of contempt cases. There still exists a high number of civil and criminal contempt cases pending in various high courts and Supreme Court. The high number of cases justify the continuing relevance of the contempt of court law. Number two, affecting of judiciary's reputation. Amendment in the amendment in the definition of the contempt may reduce the overall impact of the law and lessen the respect that people have for the courts and their authority and functioning. So this will hamper the judicial process in the long run. Also, by abolishing the offense in India, this would have a legislative gap. This would leave a legislative gap. Next is constitutional source of contempt powers. The Supreme Court and the High Courts derive their contempt powers from the Constitution. The Contempt of Courts Act 1971 only outlines the procedure in relation to the investigation and punishment for contempt. So, thus, the deletion of the offense from the Act will not impact the inherent constitutional powers of the superior courts to punish anyone for its contempt. So, they are arguing that there is a constitutional sanctity behind the contempt of court powers. These powers will continue to remain independent of the 1971 Act. Number four is the impact on subordinate courts. The Constitution allows superior courts to punish for their contempt. The Contempt of Court Act additionally allows the High Court to punish for the contempt of subordinate courts. Thus, if the definition of contempt is removed, subordinate courts will suffer as there will be no remedy to address cases of their contempt. Number five is adequate safeguards. The Commission noted that there are several safeguards built into the Act to protect against its misuse. For instance, the Act contains provisions which lay down cases that do not amount to contempt and cases where contempt is not punishable. These provisions suggest that the courts will not prosecute all cases of contempt. So, what is the conclusion that we have to draw? The Law Commission of India held that there is a need to retain the provision regarding the contempt of courts. However, it also recommended that the definition of contempt of court act should be restricted to civil contempt only, that is willful disobedience of judgments of the court. So in short, the Law Commission recommended that the criminal contempt of court should be done away with. Further, in the era of social media, besides the need to revisit the law on criminal contempt, even the test for contempt needs to be evaluated. What is the natural law, natural justice? Is it secured or not? Should be evaluated, and then necessary modifications have to be done. Now let us discuss a main question regarding the contempt of court. Judiciary in India should not really be expanding its time and energy invoking its power to punish for contempt of itself. critically analyze. So, based on our discussion that we had, please try to answer this question and try to evaluate yourself. Thank you. Have a good day.